Rise. You may be seated. The Court of Florida is gathered here today to hear the case of Clarence Earl Gideon, accused of breaking and entering into a bar with the intent to commit a misdemeanor. Mr. Gideon, you may begin.
I'm sorry, Your Honor, but I cannot proceed. I have the right to an attorney, and the court has not provided me one.
Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent you is when a defendant is charged with a capital offense. I am sorry, I will have to deny your request. You may defend yourself to the best of your ability. Prosecutor, state your claim.
Thank you, Your Honor. I am here today because Mr. Gideon broke into a bar a couple of nights ago with the intent to rob. It is evident that the night of such event, Mr. Gideon was drunk and after making a phone call on a public telephone was picked up by a taxi cab, thus leaving the crime scene within 3 minutes after breaking in.
Mr. Gideon, you may proceed. Tell us what happened that night.
I didn't do it. I'm innocent. I didn't do what they said I did.
Prosecutor, do you have any witnesses?
Yes, I do, Your Honor. We have Mr. Smith as a witness, and I would like to call him up.
The court calls Mr. Smith forward to testify.
Do you swear to tell the truth and nothing but the truth? I swear. You may sit down. Mr. Smith, tell us what happened a couple of nights ago at the bar you were in.
I was at the bar with a couple of friends when I saw that Gideon stole money and they got in a cab and left.
Can you point to the man who did that?
That man right there.
Thank you, Mr. Smith. That's all. Mr. Smith, you say you saw me at the bar a couple nights ago? What did I do?
I saw you stole money, got into a taxi cab after you left.
And what were you doing there?
I was relaxing, having some beer with a couple of friends. What else?
That would be all.
So can I leave?
Yes. Do you, Mr. Gideon, have any witnesses?
Well, no. I thought I first got appointed an attorney.
Then the prosecution may finalize the accusation.
It is known that somebody broke into that bar late at night and stole. Now, Mr. Gideon is suspected guilty, and it's been proven it was him who committed this crime. You decide.
Mr. Gideon?
I didn't do it.
I called the court on a 15-minute break while the jury was After hearing both sides, the jury has found Mr. Gideon guilty. I hereby sentence Clarence Earl Gideon to 5 years in prison.
The U.S. Supreme Court says I am entitled to be represented by counsel. The 14th Amendment requires due process of law for the deprivation of liberty, just as equally as it does for deprival of life.
Ladies, today we have received a petition for habeas corpus from a Florida prisoner who claims was not given a fair trial.
What does he base such claims on?
He says he wasn't given an attorney. He asked for one, but apparently the judge denied his request.
Well, what was the reason the judge had to not provide an attorney for the man?
According to him, the judge's response was that an attorney is only appointed for a capital offense.
Nonsense. The Constitution does not specify capital from non-capital offense.
The 16th Amendment clearly requires appointment of counsel in all criminal prosecutions and for capital crimes.
Then this also applies to the Betts versus Brady case.
That's right, ladies. Should then we review both cases?
We are responsible for carrying out the duty of the Supreme Court judges right and fair, just as the Constitution mandates.
Then do we approve Mr. Gideon's petition?
That seems fair to me.
It would be fair to review Mr. Gideon's petition and determine if Bett's case was held fairly.
Then it is set. Mr. Gideon will be granted a fair trial.